May counsel for the plaintiff please make representations?
May please the court. My lady, my lords. My name is Gabriela Makadi, and to my left is my co-counsel, Pilisile Chabalala. We will be the legal representatives for the plaintiff in this particular matter.
Thank you, counsel.
As it please the court, my lord.
If it may counsel for the respondents please make representations?
As it pleases the court, my lords and my lady, my name is Shingai Harry Dijita, and to my left is my co-counsel, Malarata Motlowung, and we shall be appearing on behalf of the defendants in this matter.
Thank you, counsel. May counsel for the plaintiff please proceed with their arguments?
May please the court. My lady, my lords. The plaintiff in this particular case humbly approaches honorable court today to raise 5 issues. Firstly, the granting of the decree of the divorce. Secondly, in the event of such an order being granted, an order granting spousal maintenance. Thirdly, an order granting full parental rights and responsibilities to the plaintiff. And in the event of such an order being made, an order granting maintenance for the minors. And last but not least, who should be held liable for the cost of the pleadings. Now, if I may, the first issue will now be addressed. In addressing this issue, it is a submission of the plaintiff that the decree of the divorce should be granted by the virtue of the fact that lawful grounds for terminating the marriage does indeed exist. Now, my lord, my lady, this does indeed occur due to the following. Firstly, when the plaintiff concluded the marriage with the first defendant, she was mainly under the impression that she's the only spouse in the marriage. When the second defendant returned, this caused confusion and tension between the marriage between the plaintiff and of the first defendant. This was, however, addressed by the plaintiff to the first defendant, but to no avail. This consequently led to the plaintiff feeling sidelined and neglected in the marriage, and which also led to her departure from the matrimonial home. After her departure from the matrimonial home, the first defendant did not attempt to go after her to seek reconciliation. Now, my lord, my lords, my lady, this clearly shows that the first defendant has no interest whatsoever in the marriage. In the court case Swat v. Swat, the court held that... Yes, my lady.
Where was Swat versus Swat heard?
In the Orange Free State Provincial Division.
You may continue.
As it pleases the court, my lady. In that particular case, the court held that when both parties are seeking a decree of the divorce, it is a clear indication that there was indeed an irretrievable breakdown of the marriage with no possible restoration. In conclusion, the plaintiff submit that sufficient evidence has been provided indicating an irretrievable breakdown of the marriage with no possible restoration. Therefore, the plaintiff sees no reason why this honorable court should not grant the decree of the divorce. If I may, the second issue will now be addressed. In addressing this issue, according to Section 7, Subsection 2 of the Maintenance Act, provision is made for maintenance order to be granted in an absence of a maintenance agreement. Furthermore, this section provides factors that the court can consider when making such an order. Among those factors are the prior conduct leading to the breakdown of the marriage and the respective earning capacity of the parties.
Counsel, as both parties have come to this court to seek a dissolution of the marriage, and the 2 factors that you name under the Divorce Act is the reason for the breakdown of the marriage and secondly their earning capacity, would you not agree with the court that the fact that the plaintiff does in fact have an earning capacity is enough to not award maintenance to the plaintiff?
My lord, thank you for bringing that up, my lord. My lord, the plaintiff does not dispute the fact that she is able to go out and seek for employment. However, the plaintiff refers to the court case Grasso vs. Grasso. In that particular case, the court held that the court rejected the general rule that rehabilitative maintenance should be awarded in all circumstances. Furthermore, in that court case, the court awarded maintenance to the wife who was still able to support herself. So it is a submission of the plaintiff that such a view, the viewpoint followed in the Grasso case, should be applicable in this particular matter.
Thank you, counsel. In terms of the clean break principle regarding maintenance, would this not be beneficial to the plaintiff's argument?
Well, my lord, it can be beneficial, but regarding that issue, what will be applicable will be whether the first defendant will be able to pay the lump sum amount.
Okay, thank you, counsel. You may proceed.
as already indicated that there are several factors that should be considered when making such an order. The plaintiff submits that these factors, the two factors that were already mentioned, should be applicable due to the following. Firstly, the first defendant has the financial means to provide the maintenance. Secondly, when the divorce issue was addressed, evidence was laid indicating that the breakdown of the marriage was caused by the conduct of the first defendant. Furthermore, it would be in the best interest of the minors that in the event of this honorable court granting full parental rights and responsibilities to the plaintiff, that a maintenance order be granted to the plaintiff. In conclusion, the plaintiff submit that sufficient evidence has been provided indicating that a maintenance order should be provided. If it may please the court, I'll now hand over to my co-counsel who will address the last issues.
Thank you, counsel.
As it pleases the court.
As it pleases the court, as my co-counsel has already mentioned, I am Pidisiwe Shabalala. With regards to the full parental rights and responsibilities of both minor children, I'll be discussing the best interests of both minor children, maintenance for the minor children, as well as limited contact between the defendants and both minor children. Counsel for the plaintiff submits that it is in the best interests of the children that the full parental rights and responsibilities are granted to the plaintiff. Section 28, subsection 2 of the Constitution states that a child's interests are of paramount importance in all matters concerning the child. Furthermore, Section 7 of the Children's Act consists of the best interests of the child standard, which are factors to be considered by the court. Alongside the relevant legislation, case law needs to be used in order to determine the judgment for this particular case. The case McCall versus McCall provides factors that need to be taken into consideration, most of which are also stated in Section 7 of the Children's Act. Another case is Sope versus Masalela and another, where the courts held that the interests of the child have to take precedence. The defendants obtaining full parental rights and responsibilities of the minor children would not be in the best interests of the minors.
Sorry, counsel. What are full parental rights and responsibilities in terms of the Children's Act?
In terms of the Children's Act, Section 18, subsection 2 states that it entails caring for the child, maintaining contact with the child, maintaining the child, as well as acting as a guardian for the child, my lord.
Thank you.
The defendants obtaining full parental rights and responsibilities of these minor children would not be in their best interests. The defendants' past conduct and history of alcohol abuse and drug abuse have a negative impact on both minor children, as this led to Temuho's condition, namely fetal alcohol syndrome. The defendants seem to place a high premium on alcohol and drug abuse, as they have spent every possible night drinking and partying whilst leaving their child with our client, thus causing them to neglect and fail to completely fulfill their parental rights and responsibilities. The nature of the relationship between the minors and the defendants also needs to be taken as a factor to be considered by the court. Both of the defendants do not have a good relationship with the minors. The first defendant does not have a strong bond with them, as he is often away on an audit, therefore he doesn't spend a lot of time with these minors. The second defendant, however, does not even try to bond with Gabelo or mother him, and she has stated that her own biological son Temuho frustrates her due to his specific needs due to his fetal alcohol syndrome. The second defendant had every intention of leaving our client with the duties of mothering her children. The second defendant also left the household while her own biological son was only 6 months of age, which is a crucial time for any development of all children. This indicates that the second defendant did not have the best interests of the children at heart, and that she was not willing to take care of the minors. On the other hand, Gabelo and Temuho are very close to our client and have a very strong relationship with her. They refer to our client as their mother, and they have expressed their views in terms of who they want to live with. And both...
Sorry, counsel. To what extent should this court take into account the wishes of a minor, who is, in this case, of a very young age? At what extent should this court attach weight to those wishes?
As it pleases the court. Counsel for the plaintiff acknowledges that the age and maturity of the child should be taken into consideration. However, in the case Bloomer versus Fanzel and Farrell, it was held that such a view must have been given freely, voluntarily, and without undue influence from outside parties. These requirements have been met. Furthermore, it would be detrimental to the children if they were to be removed from the only mother they know and the only person that provided safety and security in the Bohan household. Therefore, the court should consider the wishes of the minors to the extent that it overrides the fact that they are of a very young age. If you please, the court may proceed.
Please continue, counsel.
The first defendant has also remarked that the plaintiff is the only mother that Kabelo has ever known, and that Temuho is lucky to have had him as a caregiver. Furthermore, the environment within the Bohan household does not comply with the best interest standard due to the constant fighting and arguing.
Counsel, sorry. What you're asking this court to do is to separate a minor child from their biological mother. Isn't there case law that states that even if alternative care is available, the court should not separate a child from their biological mother?
Yes, my lady. In the case S versus M, it was held that even if there is alternative care available, a child should not be separated from their mother. However, in that particular case, it was due to the fact that the mother was a divorced mother who was the primary caregiver of her children. Therefore, it was in the best interest that the children are not separated from their mother. However, in this particular case, the second defendant is the biological mother. However, the plaintiff is the primary caregiver of the children. It would be in the best interest that the children remain with their primary caregiver, rather than their biological mother who neglected and failed to fulfill their parental rights and responsibilities.
Thank you, counsel. You may continue.
The defendants are also unable to take care of the minors. They have to appoint someone to take care of their minors as they are unable to cope with taking care of them. This is essential for taking care of Temuho due to his fetal alcohol syndrome. He needs someone who is experienced in taking care of someone with his condition. The plaintiff has been raising him throughout his whole life, so she has experienced what is needed in terms of taking care of Temuho. Therefore, she is capable of taking care of him as well as Kabelo. The plaintiff also requests that the defendants only have limited contact with the minors. The best interest of the child standard states that there is a need for a child to have a connection with their family, tradition, or culture. Thus being reason why the plaintiff requests limited contact rather than no contact at all. Furthermore, there would be a sense of uncertainty and confusion amongst the minors as they refer to our client as their mother. However, they are not aware that their actual mother in the marriage is the second defendant, and yet they would have to be forced to live with the second defendant in the event that the defendants obtain full parental rights and responsibilities. Therefore, the limited contact would assist the minors in fully comprehending their family circumstances. With regards to maintenance for the children, it is in the best interest of these minor children that the defendants have a maintenance order in respect of provision for food, clothing, education, medical care, and so on and so forth. The counsel for the plaintiff also submits that payment of maintenance must proceed whilst the defendants have limited contact. In relation to S versus Olivier, the limited contact or visitation does not limit or suspend the order of maintenance. In conclusion, the counsel for the plaintiff hereby submits that sufficient evidence has been provided to the court indicating that it is indeed in the best interest of the children that the plaintiffs receive full parental rights and responsibilities. We also submit that in the event of this honourable court granting full parental rights and responsibilities to the plaintiff, that limited contact is maintained between the minors and the defendants. Therefore, counsel for the plaintiff sees no reason why this honourable court would not make such an order in favour of the plaintiff. We hereby pray for a decree of divorce, spousal maintenance as well as maintenance for both minor children, full parental rights and responsibilities for both minor children, as well as for the defendants to be liable for the costs of pleadings.
Thank you very much, counsel. Counsel for the respondent, may you please proceed with your arguments.
As it pleases the court, my lords and my ladies, the following issues will now be addressed. A decree of divorce, the dismissal of the plaintiff's application for personal maintenance, full parental rights and responsibilities in respect of both minor children, including an order barring the plaintiff from having any further contact with both children, and an order for the plaintiff to pay the defendant's cost of proceedings. If it pleases the court, my lord, and my ladies, I shall now address the first issue, a decree of divorce. It is common knowledge that the plaintiff and the first defendant have approached this honorable court for a divorce order, and this is indicative of the fact that there is no consortium and there's been a breakdown in consortium, a necessary element in any subsisting marriage relationship. What is more, the plaintiff deserted the Bohang's household without telling either party of her intentions to leave the house, and she has not made any effort to return to the house, thereby abandoning her duties as the primary caregiver of both children.
Sorry, counsel, what type of legal system was this marriage concluded under? Was it under customary law or civil union act? Which legal principles guide the conclusion and validity of this marriage?
As it pleases the court, this is a customary marriage and it's regulated under the Recognition of Customary Marriages Act.
Why are customary marriages not regulated under the Civil Union Act or the Marriages Act?
The Civil Union Act and the Marriages Act, my lord, regulate civil marriages only, and they regulate monogamous civil marriages. Customary marriages are not recognized by those acts, and polygyny as well is not permitted by those acts. The Recognition of Customary Marriages Act was enacted so as to recognize customary marriages and the patrimonial and proprietary consequences thereafter.
Thank you, counsel. You may
If it
continue.
pleases the court, I shall now proceed with the rest of my argument. Section 28, subsection 1, item B of the Constitution of the Republic of South Africa states that every child has the right to grow up in an atmosphere filled with love, happiness, and compassion. If we look at this case, we can see that the plaintiff places very little importance on this notion, as she has constantly influenced the children constantly encouraged both children to express condescension towards their parents. In Hoyi versus Hoyi, a 1994 decision of the Eastern Cape Provincial Division.
Sorry, counsel, could you just quickly provide us with a quick background of the facts of this case and why it's applicable to this case?
As it pleases the court, my lord. In Hoyi versus Hoyi, the plaintiff instituted divorce proceedings against her husband, whose whereabouts were unknown, and she went about the action unopposed. In the action, the plaintiff sought a decree of divorce and custody for the minor child born of the marriage relationship. However, the minor child had been in custody of his grandmother since birth, and the mother had only made phone calls to the child and had not met the child. In this court decision, the court held that in the event that provisions are not made to ensure that the best interests of the child are kept, the court will refuse to grant a divorce order and will also refuse to grant custody to the applicant or the plaintiff in the matter.
Thank you, counsel. You may continue.
As it pleases the court. In the present matter, the defendants have taken primary care of both children and have appointed a new au pair to make sure that the children's progress is not curtailed as a result of the present action. The defendants hereby submit that evidentiary proof of an irretrievable breakdown has been met, and there is no foreseeable prospect of restoration of a normal marriage relationship, and the defendant submits that the court should there should be no reason for the honorable courts not to grant the order of which both parties seek. If it pleases the court, my lord, I shall now address the second issue, maintenance for the plaintiff. As correctly pointed out by the plaintiff's first representative, Section 7, subsection 2 of the Divorce Act states that in the absence of a valid written agreement between parties for the payment of maintenance from one party to another party, the court will only grant an order of maintenance after considering the respective earning capacities of the parties, the age of the parties, the duration of the marriage, the financial needs and obligations of the parties, as well as any other factors the court may deem relevant. In the present matter, the first defendant has provided for all the financial expenses of the marriage, and the plaintiff's financial position has not been jeopardized at all. Furthermore, the plaintiff is reasonably young and has no children born of the marriage or currently dependent on her. The plaintiff is physically capable of working and is an au pair by occupation and is able to sustain herself through the proceeds of her work and the additional benefits stemming from the life insurance policy already paid out to her late grandmother's life. The first defendant further submits that his marriage to the plaintiff has only lasted for 3 years, and the period alone does not warrant a maintenance order against him. As previously stated, the plaintiff has been instrumental to the breakdown of the marriage, and her conduct showcases her disinterest at being a constructive part of the relationship. Section 9, subsection 1 of the Divorce Act permits the court to order the forfeiture of patrimonial benefits, either wholly or partly, in favor of one party against another, if there is reason to believe that this benefit is unmerited. The defendants hereby submit that the plaintiff...
Sorry, counsel. In the event of this court awarding full parental rights and responsibilities to the plaintiff, would it not be prejudicial to the best interests of the children for the defendant to refuse the payment of maintenance?
As it pleases the court. Section 19 and Section 20 of the Children's Act recognize that the full parental rights and responsibilities of both children are awarded to the married biological parents of the children. In the event that full parental rights and responsibilities are awarded to a third party, this does not waive the right to maintenance which the biological parents have to carry out towards their children. The defendants hereby submit that the children will be provided for financially and they will not be subject to poverty, nor will they be dependent on the plaintiff's salary for their upkeep. However, the plaintiff still has to apply and prove that she needs maintenance, as awarding maintenance to the children does not equate to her being granted maintenance.
Thank you, counsel.
If it pleases the court, the defendants hereby submit that the plaintiff's claim for maintenance be dismissed for all purposes, as it is not the duty of the court to maintain the standard of living that the plaintiff had become accustomed to during the course of the marriage. If it pleases the court, I shall now hand over to my co-counsel to address the remaining issues.
Thank you, counsel.
As it pleases the court. As my co-counsel has already mentioned, my name is Mootcourt, and I shall be addressing the following issues. Firstly, the matter of full parental rights and responsibilities in respect of both minor children. Secondly, the express views of those children. And lastly, the prayers and conclusion. If it will please the court, can I please proceed to the full parental rights and responsibilities? In all matters that concern the livelihood, care and welfare of children, their best interest must be placed as a matter of paramount importance. These interests are protected by both international law and national law. In South Africa, that would be the Constitution, legislation, and the courts. It is in the Children's Act 38 of 2005 that we can find a standard to which to determine what would be in the best interest of both minor children. And this, the standard is provided for in Section 7, subsection 1. Firstly, in terms of the personal relationship between the defendants and both minor children, it is clear that for all intents and purposes, the first defendant is a good father. Not only is he the sole provider of both minor children, he has maintained a very good relationship with both children, providing for their safety and security and a safe and secure environment for them to be brought up in. It is the second defendant's relationship with both minor children that may prima facie appear to be weak. However, as representatives for the defendants, we shall prove this not to be so. As has been mentioned by the counsel of the plaintiff, that she has shown resentment and possibly fear towards both minor children, it is not, this fear has not been shown towards both minor children, but rather at the situation she unexpectedly found herself in. And it is the events that have occurred in her past that have caused her to act in such a manner. Firstly, upon entering into a relationship with the first defendant, the second defendant was at a very young age. It was a relationship that was not based on family-orientated values, but rather on the fast life, the party life. And she herself has admitted to having had a bad childhood. Therefore, she has not had an example of what a good mother is supposed to be, or what a family dynamic is supposed to work. However, she has returned to the marital home, and she is willing to undergo rehabilitation. And this should be an indicator to this court and not a deterrent to show that she is willing to take up her spot as a mother and as a good parent to both minor children. In terms of the ability for both parents, for both defendants to
Counsel,
provide...
could you just quickly provide the court, what do you mean with ability? Is this financial means or is this a parental ability to take care of the children?
As it pleases the court. When we refer to the ability or the parental exercise, the full parental exercise of their rights, we refer to the whole picture of what the child's abilities. We refer to the full picture of what a child's needs are, This not only includes the financial needs, but as well as the emotional needs, the intellectual needs, and any further needs they may need in the past and in their future.
Sorry, Councillor, you've mentioned that Section 7 sets out the requirements that need to be taken into account in determining the parental rights or the best interests of the children. But which section in the Children's Act states that the welfare and whenever the welfare or well-being of a child is an issue, the best interest standard has to be promoted and protected?
As it pleases the court. It is in Section 9, Section 9 of the Children's Act 38 of 2005 that it is stated that in all interests that and concern of children, their best interest must be taken into as placed as a matter of paramount importance.
Thank you, Councillor.
In terms of the ability to provide for the needs of both minor children as well as the full exercise of parental rights and responsibilities, the defendant's capacity to provide for the financial, emotional, and intellectual needs must be evaluated against the background of Demoho's developmental issues as well as Gabelo's tender age. The defendants are better equipped to provide for both minor children's individual needs, namely a suitable place to live that is conducive to their health and well-being, the necessary financial support that is needed currently and for the future, as well as a safe and secure environment for them to grow up in. Separation from the defendants could lead to detrimental effects. Firstly, this home that is provided by the defendant is the only home that both minor children have ever known. It is a safe and secure environment that has brought them to the stage that they are right now. Furthermore, the defendants offer the benefit of having both parents being there for them and to guide them in their growth. And lastly, the United Nations Convention of the Rights of the Child provides that it is the right of the child to be afforded a family environment, and it is such an environment that the defendants are providing. If you will please the court.
Counsel, before you finish, I see here in your prayers you asked this court to make an order barring the plaintiff from any contact with the children. Given the fact that your co-counsel himself has stated that she was entrusted with being the caregiver, and that the plaintiff has said that she is the primary caregiver of the children, would this prayer really be in the best interest of the children?
It is in Section 28, subsection 2 of the Constitution, which states that in all matters that concern the rights of the children, their best interest must be taken as paramount importance. And the Constitution is the supreme law of our country. Therefore, if it is to the best interest of both minor children that contact be barred from the plaintiff, then this should be so.
Thank you, Councillor.
Thank you, Counsel.
If you will please the court, I'd now like to move on to the express views of the children. The African Charter on the Rights and the Responsibilities of Children provides that it is the right of every child to express their views and for that view to be taken into consideration. However, as was mentioned already by the plaintiff, that such view must be firstly given voluntarily, freely, with no undue influence, and secondly, that the age and maturity of that minor child must be taken into consideration. In terms of the first requirement, this opinion that Gabelo has expressed has not been given freely or voluntarily. The plaintiff has herself encouraged Gabelo to express such views, as well as place her undue influence upon Gabelo. Secondly, on the second requirement, upon the age and maturity of the child, it is to the discretion of the court to decide whether or not Gabelo, who is age 10, can fully understand the repercussions of removing full parental rights and responsibilities of not only himself, but that of his much younger brother to a third party. And we as the defendants hereby submit that these requirements are not met. If it will please the court, I'd now like to move on to the conclusion and the prayers. As representatives for the defendants, we hereby pray that, firstly, a decree of divorce be granted for all the requirements thereof have been met. Secondly, that the plaintiff's application for personal maintenance be dismissed. Thirdly, that full parental rights and responsibilities in respect of both minor children remain in the care of both defendants. An order barring the plaintiff from any further contact with both minor children. An order for the plaintiff to pay defendant costs. And lastly, any further or alternative relief that this court may deem necessary.
Thank you, Counsel. Thank you, Counsel, for both parties. Your oral and written submissions shall be noted. Judgment is reserved on this matter. Questions?
Ladies and gentlemen, just to give you a little synopsis of what actually went down in that matter, it was a matter concerning a divorce, an application for divorce, but specifically they were looking at the best interests of the child, between a mother and father involved in a divorce dispute, as well as various other aspects such as maintenance that were also covered. These were only small sections of these particular arguments that were covered. Usually our students are able to address a lot more in their arguments. We teach them and we give them the necessary skills to engage a lot more in their particular arguments, as well as to read and write critically. Family law is one aspect of the moot courts that our students are able to do. Our students are also get an opportunity to do moot courts concerning commercial matters. We recently had some of our senior students take part in an arbitration moot court competition in Austria, and they also take part in other commercial and even criminal law moots as well. I trust that all of you have enjoyed this demonstration. I believe that we can have a question and answer session if you prefer. If anybody has any questions or queries with regards to this moot court or to this demonstration, we'll be glad to answer. Everybody's happy and relaxed. Ladies and gentlemen, if you have not been to our stall for the Faculty of Law in the tent, I'll be very glad. It will be my pleasure to escort you there.